The old hag busts in. She's there. Oh my gosh, what is she doing? Why is she here? This is terrifying me. And she has something in her hands. And she goes, Judge, I have his will. They lied to you. Do not go downtown Dallas to find an attorney. They bill like $1,000 an hour, and they bill all the time. They never stop. In a month and a half, he billed almost $200,000 before the family got rid of him.
Tonight, we're talking about estate planning and all the various things that entails. And I'm just here primarily to introduce you to the team that I've been using for 15 years for this. We'll start with the lovely Andrea. I clearly have not been using Andrea 15 years because she would have been like 11. But she's a young, brilliant attorney at the Willingham Law Firm. And she went to a fantastic school. She's extremely caring. She's very patient and quite professional. We have Carla. Carla is not only an attorney, but she actually has a master's in taxation, which means she even knows more than me about taxes, which she also is an expert in special needs planning. So if you have anybody in your life that could benefit from that, she's excellent for that. That's me. That's my lovely bride. I have Guideline Capital Management as my boutique practice. I focus on several areas. Estate planning is one of them. Retirement income planning is a significant one. Tax planning, and alternative investments. And lastly, the person that's going to be talking to you tonight, for the most part, is one of my best friends, Taylor Willingham. I've known him since 2009. We've worked together almost since that point. I have been thinking about writing a book for the last 10 or 15 years, and during that time, he's written 6. That should tell you which one of us is better at getting things done. The best thing about Taylor, I can just attest to this, is where his heart's at on things. I've sat in meetings where people come in and they're ready to sign whatever, and he lets them know that they don't need to do anything. And that's a pretty telling characteristic for an attorney. On the flip side, he's also somebody that will go to bat for people and tell them exactly what they need to hear, even if they don't want to hear it. But one of the greatest things about Taylor is that his practice encompasses everything from single moms that are working double shifts all the way to folks that have multi-million-dollar business empires. So with that, I'm going to introduce you. Taylor, come on up and do your thing.
All righty. Okay, we're going to jump in. So what is estate planning? Overall, it is planning for 2 situations. One is when we pass away. Every day that none of us are in this room, none of us will be around, and when that happens in each one of our lives, what happens not only with our assets, but how do we handle things so families don't fight, we don't blow up the whole situation in our own little communities that we have. And then number 2 is incapacity planning. Okay? There's a high likelihood if you live past 60, it's about 50-50 shot, you're going to spend some period of your life in a skilled nursing facility or assisted living facility. Just because it's the nature of the game, the older that we get, we lose our ability to actually handle our own affairs. I'm sure everybody in this room has felt it. The older you get, you're just a little bit off physically and mentally. Slows down just a little bit every year. Gets in one of my books I wrote, I have a chart that shows how significantly that happens in your 80s. It's shocking how fast decline happens. All right. So how we do everything in life, pretty much, is we put things in writing. And there are certain documents that we use in estate planning that are very central to what we do. Okay? And what those documents are, first is the last will and testament. One of the things I love is I love history, and I have a lot of historical stories that are in my book. If you look on the front, there's a picture of an old lady right in the middle. Okay? That old lady is, of course, not this person, but it's about one of the oldest wills that we ever found. 4,000-year-old will that comes from Egypt. And the fascinating thing about Egyptian wills that we find is they're still done the same way. They have to be witnessed by 2 people. It's kind of crazy, but we still follow that same pattern today. And I love her story because I love what she put in her will. She said in her will, I have 8 kids, but I'm leaving nothing to 4 of them because they didn't take care of me when I was in my elderly years. I thought, wow, isn't that amazing? 4,000 years ago, still doing the same things that are done today. But that's what she should have done. Yeah, I mean, the other 4 were taking care of her and doing good stuff. But in our situation, wills have been around forever. They are so essentially to the core of what we do in estate planning. The next are trusts. Trusts are not wills. If you read the title in this book, do I need a will or a trust? The reason why I named this book this is because I get this question all the time. And the hard thing that I have to say is, if you read the very first beginning, I answer the question, wills and trusts aren't the same thing. So that's the wrong question to ask, because trusts do different things. You always need a will. The question is, do you need a trust? And the essential thing to understand there, what is a trust? What does it do? What are those weird documents that people talk about all the time? And it's very simple. Anytime you take a piece of property and you divide the right to manage the property, the legal interest, from the beneficial interest, you created a trust. We have it happen all the time. People will write a document. They'll say something like, oh, well, Billy is supposed to run the farm for his siblings. Even though he didn't call it a trust, he didn't do anything like that, the judge will say, he created a trust. That's what he was trying to do. He didn't know that he was supposed to do that, but that is what a trust is when you divide interest in the property. Okay, the next, the durable power of attorney. Out of all the documents that you can do, I will promise you, this one is one of the best that you can do for you. Because if you become incapacitated, guess who shows up to take care of you? Who shows up to help you if you have money? Yeah.
People you don't know.
People you don't know, and and sometimes the kids that you don't want taking care of you. You're a good, responsible kid. He or she has a job. They're busy. And the last thing they want to do is now have to take care of their parent, because they usually have kids themselves. They're organized. They're structured. It's very difficult for them. The kid that wants to take care of you is the kid who doesn't have a job, needs money, and goes, oh, yeah, I'll take care of mom. Moves mom into the house and takes her Social Security check, and then we have to call Adult Protective Services because they're, taking everything. That's what happens. So that's why we need it. And you do not want to have to go get a guardianship over somebody. It is not a fun experience. I'll get to it a little bit later. Medical power of attorney. It's the idea, okay, who's going to make my medical decisions? Because often who makes your financial decisions is not the person you want to make your medical decisions. Okay? There's some people that are good with money and some people that are usually very good with people. And it's balancing that out and figuring out. And I tell people all the time, this in my office, you need to sit and think about this. I ask the question all the time to my clients. If you are in a nursing home, who is going to help you? And that, my friends, is a deep question. When you really start thinking about that, you really start figuring out who is your real friends, who are the people that really love you. If you had nothing, who would be there for you? You don't have anybody, time to work on some relationships. Living will, the directive to physician. Okay, this document is the document if you are in a terminal or irreversible condition. There's nothing more the doctor can do for you. They're using some form of technology to keep you alive, some kind of machine, something. Do you want them to keep you alive, or do you want nature to take its course and let you pass away? Okay? The reason why we do this document, it's incredibly important, because if you end up in a long-term care situation, Medicare does not pay for it. You got to pay for it now. You say, oh, I want to be kept alive as long as possible. It's up to you. You got to finance it somehow. Because Medicare does not cover long-term care. It's a shock to many families to find that out. It's not going to finance that. You have to finance it on your own. So we do this document for a lot of people because they want to say, hey, I don't want to financially drain my family. I want nature to take its course and let me pass away so we don't run out of money. And guess what? Medicare has this really nice thing. They say, well, if you'll do that, if you'll go on hospice, we'll pay for your care then. So if you'll agree to die, we'll help you out. Yeah, the government, once again, doing great things for us. Beneficiary designation is the #1 way we transfer assets now. Most people don't understand this, but when you give your money to the bank, it is no longer your money. It is the bank's money. And they have a contract with you to keep and pay you out certain amounts, like they pay you interest and stuff. But if they go bankrupt and lose your money, you don't get to go and go, you stole my money, I'm going to go down to the DA's office and report you. You get insured up to $250,000 from the federal government, but after that, it's you took the risk of putting your money with the bank. Okay? So because it's no longer your money, you have these contractual relationships with the bank. They have an agreement that when you pass away, they'll pay to whoever you ask them to pay. We call those beneficiary designations, or transfer on deaths, or pay on deaths. Those are great. It's a great system. It makes things very easy for your family. So when someone passes away, just go to the bank, give them the death certificate, and then they pay the money out. Makes it very simple to handle things, but they cause a lot of problems in estate planning. Like, for example, the number one problem I have. So this kid comes into my office, and he goes, my mom left me as beneficiary on her bank account. She had $300,000 in there. I was told that it's my money. Is that true? I go, yeah, you're the beneficiary. It's your money. You can do whatever you want with it. I go, why? And she goes, well, she told me to distribute it equally between the siblings. I said, oh, well, maybe you should honor what your mom's wishes were. He goes, do I legally have to? I go, no, you don't really have to. It's your money. She left you as the beneficiary. There's no legal obligation there. And you could see in his face this sickening feeling of being put in this dilemma, that in his hands will hold more money than he will ever have in his lifetime, and he's supposed to divide that 5 ways. And his mom put him in the worst position. I never saw the guy again. I don't know what happened. But I can tell you, from what I saw leaving that office, he wasn't planning on distributing it to his siblings. All right, the next, guardianship designation. Okay? This one isn't as important now. It's becoming less important because we passed a law in Texas that we basically look at the durable power of attorney to decide who your guardian will be. So this one's kind of fading out. It used to be very important, but we want to avoid guardianships at all costs. But these are the core documents, okay? Other than the trust, most everybody needs every single one of these in some form, okay? Sorry, that and the guardianship designation one. Trusts are, maybe you need it, okay? Now here's the other problem. Often people will say things like, I need a trust, okay? I was told I need a trust. And so in this situation, when we have this thing, I go, okay, well, I made this list up. It took me about an hour. I just said, okay, think of every trust you can think of. And I just typed it up. There are thousands and thousands of different types of trusts that are out there. Okay? Because there are a lot of different reasons why you separate the legal interest from the beneficial interest. So when I'm an attorney and I'm sitting there with somebody, I'm trying to figure out, okay, what trusts do they really need? Most people, when we create a trust for, we actually don't really create one trust. We create one master trust that has 4 or 5 sub-trusts in it. Because different things happen. Different people inherit, and different people need money and things to happen for different reasons. I often tell people this: a good estate planning attorney is usually they will make you far more money in the end than you'll ever pay them, usually 10 times over. And I use this as an example on my webpage to show just situations I've dealt with, and this is not all of them, these are just a few of them. One was a guardianship after mom did not have a power of attorney, so they had to go get a guardianship. But it ended up, because people don't understand this, when you go get a guardianship, the court hires an attorney to represent the person who's being claimed as the ward. And guess who has to pay for that attorney? Mom has to pay for the attorney. And so, mom, you're paying for an attorney to represent you, but mom should have to pay for that if you win. She's paying for an attorney. And when there's a question, what do you think that attorney's doing? They're trying to bill, yes. We're attorneys, we're like trolls. Like, we live under bridges in dark places and we like gold. It's like, this is our problem. So it just kept racking up and racking up and racking up until finally everybody, the kids and everybody just said, okay, fine, we're done. We're not going to do this anymore, okay? And when we went through the whole process, and then we had to restart it up again. But after it was finally appointed, they had spent almost $30,000 when she could have just got a power of attorney and none of this would have been an issue. It's such a disaster. Now, another case I had that happens all the time is the number one time theft happens is when someone dies. Right after the funeral, runs into the house and starts grabbing things and then runs off. And you're like, what are people doing? People come in and lie all the time. I have a title company too. So one of the things we do is we sell houses. We are lied to all the time. Oh yeah, I don't have a brother. I don't know what that obituary says I have a brother. I don't know who that is. Okay? One case I have, the one that's up there, is grandma had a $3 million piece of property. She didn't do anything. She passes away. And grandson comes in. This is a hero. He comes in to be the guardian. Doesn't really take care of her. Puts her in a nursing home. But takes control of her money. But by the time I got a call from the judge to say, hey, your client has stolen property from this estate. He's lying to everybody. She died a year ago. She's not alive. There should be no guardianship anymore. And I had to go track him down and everything. He had already spent about $2 million of it. It was a 7-year case, and after 7 years of dealing with this case, he ends up killing himself during that process. It was horrible. The worst was the judge had me involved in it for 7 years, and I didn't get paid a penny in the whole freaking thing at the end of the day. I had to deal with this crap because I felt guilty that I represented a guy that stole $2 million. And so, it was a lesson learned. Don't ever, when a judge says, hey, will you do me a favor? You say no. You know what I'm saying? Another judge told me, he's like, how's that case that you're tied up in going? And I'm like, horrible. He goes, Taylor, no good deed goes unpunished. You never say that you're going to help out. You just say, someone else can do that. All right. $248,000 in long-term care. I have had situations over and over and over. People come to me all the time. Their spouse is in a nursing home. They're spending $10,000, $6,000 a month on the care. And then finally they go, maybe I should go talk to an attorney to see. And I have to say, yeah, you can absolutely get help. You have rights where Congress has protected certain assets. So what we call the community spouse does not have to be impoverished. Happens all the time. And it's sad when I have to tell people, I can't get the $250,000 back. I can get you help now so you don't keep losing more money. $23,000 in probate is very common. I put this one up here because it was uncontested. But there was things that just kept happening and happening. It was totally avoidable. Simply, if they were just gone into an estate planning attorney and just put things together, none of those costs would have happened. One of my worst cases that I ever had to deal with. It was so sad. Daughter took care of mom for years. And everybody understood mom in her will left everything to daughter because of what she did. She had about $1 million. That was it. And she left it to daughter. And right when mom's in the hospital dying, grandson, who's an estate planning attorney, shows up, puts, all these documents in front of grandma, sign everything, and then subsequently steals the whole estate. And we have to file a lawsuit, and I have to go through this, and I had to sit down with my client, and I go, I understand what has happened is wrong, but at the end of the day, I have this conversation all the time. I go, there are 4 kids here. There are going to be 4 attorneys because they all hate each other. The attorneys will get everything. You need to work it out with your siblings. Figure a way to work this out. Because I promise you, the attorneys will get everything. They will bill until you guys agree. Because we know what's going to happen. I told them exactly what's going to happen. The will now is invalid. And so everything is going according to state law, and you guys divide it equally. That's what's going to happen in the end. My client got on board, but the other ones didn't. And most of those fees were not mine, but they were a particular attorney that if you go downtown Dallas, you're going to pay downtown Dallas fees. Do not go downtown Dallas to find an attorney. They bill like $1,000 an hour, and they bill all the time. They never stop. In a month and a half, he billed almost $200,000 before the family got rid of him. All right, and then another end-of-life expenses. That directed-to-physician I talked about, that living will that I talked to you about. Now, I have it all the time that family members keep people alive, and then they have to start paying, and they're fighting over that issue when a direct disposition would have just resolved the issue. And there wouldn't have been a whole bunch of costs, especially in like blended family scenarios. Alrighty. Okay, we're going to play a game, guys. The game today that we're going to play is you're going to represent one of my clients. I'm going to ask you questions. I'm going to tell you her story. And then you got to tell me, what do we do? Okay? And the best way to understand estate planning is to understand what happens when someone dies. Because now, in this story, you guys will get to see what will happen, what happens. Now, this one's a little crazy story, but it's a true story. So let's go through it. Okay? All right. Cynthia, and if you want to read a little bit about it, I don't want people going to Collin County Probate Court records and looking her up and finding her story, because you can find out everything online because her case is very public. Yes, it's not really Cynthia and the husband's not really Richard, but it's in chapter 10. I tell a little brief thing about blended family nightmare scenarios. Okay, so I got to give you the backstory, because you got to, when people come to see you, they tell you a story, and then what attorneys do, we get a story, and then we have to apply the law to it. We have to figure out what's going to happen. So you got to be an attorney, you got to put attorney hat on, and think like an attorney would think. Okay. So Cynthia is she was a poor little girl from the Philippines. She grew up in this village, and one day she's online and she meets her love of her life, a 62-year-old man from McKinney, Texas, that has a bunch of money. And he flies to the Philippines, and they get married, and he brings her back here to the United States. And they're living here. Now, Richard was married before, and he had 3 kids with his previous spouse. And he ends up having a kid with Cynthia. So he ends up having 4 children, okay? Now, one important fact that you need to know about Richard is Richard was married to a crazy woman at one time. And after they went through a divorce, he spent 8 years in litigation against her. And it was so bad, the judges, through those years, awarded him $185,000 in judgments against her because she was such a disaster of a human being to deal with. They felt so bad for Richard. They kept applying attorney fees that Richard had to accumulate for defending himself because of frivolous things that this lady would do. Okay? So, you're now told Richard has passed away. Cynthia has now come to your office, and she's sitting before you. What do I do? Well, first thing is we need to know what he had, right? So this is the breakdown of pretty much what they had, but not everything. Okay? We got our kids here. We can see his 3 children from his first marriage are all older than his wife. Okay? He has Isabella, that's 2. And this is the property that they have. A home that was paid off. He had $1.5 million in a 401k, $375,000 in a joint checking account with Cynthia, 2 cars, $295,000 in a brokerage account. Brokerage account is like an investment account. Okay, so when you're dealing in probate, you want to know, okay, well, first off, is there anything that we're actually transferring here? Because, well, we'll talk a little bit about what probate is here in just a second. So the first question I have, who gets Richard's property looking at this up here? Mind you, there's no will. There is no will. There is no trust. Who gets Richard's property? Who do you guys think? Who do you guys think will get the property? Let's just go through one by one. Home. Who do you think gets the home? Cynthia. Who else do you guys think would get the home? Children. Who gets the 401k? Is there a beneficiary set up on that bank account? We need to know that. We don't know that yet. Okay, she didn't have that information. Okay, so she came to the office when she first came to see me. I don't know. I don't know if there's beneficiaries. So that's good. We have to identify that. But let's say there's no beneficiaries. Well, what actually is the rule? Now, the $375,000 in a joint checking account with rights of survivorship. Who should get that? Cynthia. Okay. 2 cars. Both are in Richard's name. Who will get the cars? So figure out if it's community property or separate property. So that's a distinction that has to be made. Now, we probably can make an assumption here. Most of this is probably going to be separate because Richard is much older and they've only been married for about 2 years, right? Because Isabella is only about 2 years old. So most of this is probably Richard's separate property. There might be some community, like they purchased a car when they were married, that might we have community. Let's say it is community property. They purchased a car during marriage. Who you guys would think would get it? Cynthia, okay? And $295,000 in a brokerage account. We do it once again. We do, first of all, is there a beneficiary? No beneficiary. We have no will, so we go according to state law. So now, let me tell you how it really will work. The home. The home is a separate property because he owned it before marriage. So, the house goes to the kids, to the 4 kids equally. And she gets 1/3 life estate. So, she gets her homestead right still. She gets to live there for the rest of her life. And the kids are responsible for what? They don't have to pay the taxes. She has to pay the taxes and she has to pay, what?
Maintaining the property.
She has to maintain the property, but they have to do one thing. What is it that they are responsible for? Insurance. Because they own it's their property. Okay? So, these 4 kids have to now pay the insurance for Cynthia, who's younger than 3 of them. So they may never receive this property ever. And then the 401k, well, we don't really know yet because we don't know if there's a beneficiary on there or but if it goes according to state law, it's his separate property. So the kids will get, so we treat separate property differently. Separate real property, you get that 1/3 life estate. Separate personal property, like accounts, it's divided 3 ways. 2/3 go to these 4 kids. 1/3 goes to Cynthia. That's how we do it under the law. When you have no will, this is how we do it in law, and you're a blended family. The key here is blended family. I want to make something also clear in this scenario. This is a blended family. If all of the children were with Cynthia, then Cynthia would just get everything. We only do it this way because they're a blended family. Because why would we make the law like this? Why would we not give property to a spouse and give so much to the kids when you're a blended family? We know if it all goes to Cynthia, she's going to go kick those kids out and they're not getting a penny of this. And it's all going to go to Isabella. So we want to protect the 3 other kids. That's what we're doing. That's the way we look at it. If you're a blended family and you're not going to do it, then this is what's going to happen. 2 cars, okay? The one was community property. The one, she retains her 50% ownership of the community property. His 50% ownership goes to the 4 kids. The other car, it divided 1/3 because it's separate personal property. And then $250,000 in the brokerage account. Let's assume there's no beneficiary set up. It'd be the same way. 1/3 to Cynthia, 2/3 to the kids. And this is the law. If you think I'm making this up, this is where you can go look it up. And we explained how blended families, we divide the property because people are shocked when they walk into my office and I have to tell them, you're not going to inherit your spouse's property. You just lost a significant portion of your wealth because you didn't do anything about this. It happens all the time. Are the kids really treated equally? I want to ask you this question. I want you to think about that. They're all getting 1/4, but is it really equal? Okay, it depends on their beneficiaries. Let's assume they all got 1/4, got the same amount. Let's say it's $100,000 each. I know it's a lot more than that. Who really gets shafted in this? No, not the oldest. He got the biggest benefit. The opposite, right? Because why? What did the oldest already get and these 3 get? He's already supported them all the way up. They had all their schools paid for. He had done everything for them all the way up to this point. Isabella hasn't had anything. She has to live off the $100,000. And this happens all the time in planning. In the law, we don't do what like other states, like Louisiana does, where we give 4 shares. We go, oh, we got little minor kids here? We're going to make sure they're taken care of first before all you other older kids get money. It's like, we don't do that in Texas. And that's a problem because when you have these scenarios that happen, it's very unfortunate because this little kid now usually ends up on some type of government assistance because they're not actually taken care of. Does any property need to go through probate? Probate is the process that we use to pass property from a deceased person to a living person. If we have to do something through some kind of legal mechanism, then we call it the probate process. Beneficiary designations, we don't call it because it's contractual. It just goes automatically. There's nothing that needs to be done. But when you have to use a court or some kind of legal mechanism to transfer that property, we refer to it as probate. And there are 7 different types of probate. Okay, so it's very difficult when people come in. They're like, oh, do I need a probate or do you not? I'm like, what I'm trying to figure out is what's the easiest type of probate we can do. The worst type of probate is when you have no will and you have a lot of assets, because we have to do 2 of the probates. We don't get to just do 1. We got to do 2. Okay? Freeze found this out today. All right? Like we're dealing with man, look, there are fees everywhere in this thing. So the 2 probates that we have to do is the first one is what we call the determination. So in probate, there's 2 main areas. The one area is we got to figure out who the heirs are. Okay? We got to establish that legally. The second is we got to administer the estate. Okay? Someone has to transfer the property. Someone has to go get it. Someone has to pay creditors. Someone has to send notices out to creditors. So we have this 2 process. Sometimes we can avoid the administration of an estate because there's no creditors and it's very obvious who can get the property because you had a will. You at least had a will done, so we could just give the money directly to the beneficiaries. Okay? Determination of heirship, the process is this. So you have to go hire an attorney because you can't represent an estate. Some probates you don't need an attorney, but in these ones you do. You have to go hire an attorney. We have to file a bunch of documentation. We have to put notices in the newspaper. We got to do all that. Then we got to go together. We go to a judge. Before that, we'll hire an attorney to represent the unknown heirs, because you might be lying. So the judge is going to hire someone to see if you're telling the truth. And this is where all kind of crazy stuff happens, where you start finding out. Women, you guys all know your kids. Men think they know all their kids. Okay? And that's the ones that we get the surprise. Okay? We're going through the process, and you're in court, and then all of a sudden, someone walks in, and you're like, who's that person? And the person's like, I don't know who that person is. And then you go, are you sure? Because there's no one else on the docket today, so they have to be here for your hearing. And then you find out it's his kid from 60 years ago. That happens, not all the time, but it does. And it's shocking to find out your spouse has a kid. All right, so the other one that's a shocker is to find out you're not the spouse of your spouse. You're like, how is that possible? I got a marriage certificate. So you get this paper that says you're a spouse. However, if your spouse was married before but never got legally divorced, because remember, when you go get married, there's no process to verify that they never got divorced before. You are the second spouse, and we don't allow bigamy in the state of Texas. So we automatically void the second marriage. So we have had cases when 30-year-old wife, way out in nowhere, gets a call. You're actually the owner of all this property. That's a shocking thing to experience. So, if your spouse was married before, make sure you know where that divorce decree is. I'm going to verify this today, and you're going to tell me for sure if you are actually divorced, okay? So we have to go through that process, and that's what the ad litem does. That's their job. They go and they look at those records and they verify everything, and then they show up at court and we have a hearing, and if everybody agrees that these are the heirs, the judge will sign an order, these are the people that are going to inherit, and then the judge has the honor to appoint the administrator of the estate, someone who's going to go through and do it. And sometimes that's a battle. We have to fight through that because there's a bunch of kids that want to do it, or I don't want my stepmother being the administrator of the estate because she'll steal everything. We have to deal with that constantly. Okay? All this process, most of this process right here, we still have to go through probate, but a lot of these issues are easily resolved with a will. You do a will. We don't need to determine the heirs. We just look at the will and say, oh, they're the heirs. We're going to give the property to these people. And you don't have to worry about who's going to be the administrator because you name your executor in your will. That's why those 2 things are very important when we create a will. That's what we're trying to do. We want to avoid those 2 problems. So now we get deeper into the story. We're sitting there, and I have to tell her, Cynthia, poor Cynthia, that she is going to have to file certain documents, and I start gathering information from her, and she goes, why do you want to know the birth date of Isabella? I go, well, I got to put that on the documents, on the application. She goes, oh, I don't want to probate then. That doesn't make any sense. Why do you want to probate? Well, turns out Isabella got pregnant before she was married, and she comes from a very traditional Filipino family. that if they found this out, that she got pregnant before they were married, they would not be very happy with her. And so she did not want that to be a public thing. And so she gets up and she just leaves the office. She's like, I'm not doing this. I don't care. I don't care if I'm supposed to probate. I don't care about any of this stuff. I don't want to deal with this because I don't want my family finding this out. It's very embarrassing because in her culture, it's embarrassing to know stuff. It's embarrassing disinheriting people. You want to go through, see some embarrassing things. Go read 1700 wills. And people did some embarrassing things back then. Shocking things. You're like, oh my gosh. 2 weeks later, she comes back to my office. She had a change of opinion because Jake tells her, if you do not probate this estate, I'm going to go probate. And then she starts realizing, oh, well, then he's going to be in control of everything, and I don't want that. So she comes back to the office. She's back in your office. Now, Jake, he is very upset, and he found out, he went and talked to someone, and they told him he's actually the one that should get everything. Now he's calling him in your office. I want my money, and I want it now. All right? I want that house sold. I want you to do all the things. And then you're having to calm. Okay, Jake, that's right. She has some rights. Like you can't kick her out of the house. She has a right to live there. She has all these things that are going on. But he doesn't care about that. He's trying to figure out how is he going to get everything. And she comes in at this point and drops a bomb on you. The ex-wife is still the beneficiary on the 401k, the $1.5 million. All righty. Okay. Now, most of you might have heard that if you get divorced, it cuts you out of beneficiary designations. It actually does on some things. Checking and savings account, yes. A will or a trust, yes. A power of attorney, yes. But not federal things like 401ks and IRAs and some life insurance policies. Or is it some annuities too? And so she drops this bomb on you. $1.5 million against the woman that tortured this poor soul for 8 years. Oh my gosh. Yeah, she is laughing in his face now. I took your money. I got it in the end. Because she got half of everything during the divorce. I mean, she got a ton of money and she just went and blew it. But if you guys remember the slide before, I was holding something right in front of me. We're super lawyers, right? There's actually a company called that does these designations. They call them super lawyers, and they give you this plaque and everything. And so we're all in this room. We're all super lawyers, okay? You don't just roll over when you're a super lawyer. We got to fight back, okay? So we're going to fight back. What should we do? We hear. I told you guys a fact at the very beginning of the story that might be beneficial to know in this situation right now. What was one of the things about the ex-wife and Richard that might be important to know? And like all good super lawyers, we go to war, right? We're going to fight this out. We're going to teach them a lesson. And when lawyers go to war, what do? We file motions, all right? So we're going to file a motion to deposit all that money into the registry of the court. You're going to have to come and fight for this $1.5 million. We're going to make you take it from us, okay? Because yes, we have an argument. She owes him money. $185,000 is a lot of money. That judge, she shouldn't be allowed just to get that 1.5 million. You need to force the 401k company to pay it to the registry of the court. Starts terrifying, her side, because now the money's in the registry of the court. How is she going to get it back? Okay. All right. So of course, she's not happy about this. She's very, very upset. And when you're going through the probate process, you have to go to court and do what's called a prove-up hearing. Meaning, this is the opportunity. If anybody wants to challenge anything, if anybody has any kind of disagreement here, it is your moment. We used to actually have to go to court. Now we just get to do it on Zoom. It's great. I can sit in my office and not have to actually go into the courtroom. But back in the day, we would have to go in the courtroom. And so we're in there, and all of a sudden, the old hag busts in. She's there. Oh my gosh, what is she doing? Why is she here? This is terrifying me. And she has something in her hands. And she goes, Judge, I have his will. They lied to you. The old hag had been keeping his will for the last 10 years, waiting for this moment when he died so she could go and probate it. Because it says on there, who's the benefit? Who does she think is going to get everything? Her. And you're like, oh, good. I paid attention in law school, so I know that what happens when you get divorced is they treat you as if you died. Okay? And luckily in that document, he didn't cut out Isabella because he left everything to his children equally. So the same thing was going to happen pretty much that was going to happen before, except for we now have a problem because he left all of his property to his kids. So the separate property, 1/3, becomes a lot more difficult to make a claim to. So anyway, we won't worry about that right now. But we think we have defeated a very nasty thing, except for it applies to her. And in that will, he put her father as the trustee of all the kids' money. And you thought she was bad. She might be a witch, but he was the warlock. He did not like how his daughter was treated throughout the last 10 years. And he was going to make this poor young Filipino girl and the daughter abomination pay for what they have done. Oh yeah, the dad was old. They drug him in there, and he's going to come in, and he is supposed to now be the trustee of all, or only Isabella's money, because the other ones were all over 25. They just get their money. But the trust in the will said anybody under 25 is going to be held in trust. So he only shows up to be Isabella's. Why does he want to just be Isabella's trustee? Makes no sense. Like, this isn't your grandkid. Why do you think he's doing it?
Control the purse strings,
Yeah. He just wants to make their lives miserable. Because that's how some people are. Okay? So what do? We're super lawyers. We got to figure out something. What do you do in this situation? It was his will. She literally had secretly thought for I guess it was 12 years later that one day she was going to get everything because she had his will. She thought that this was going to work. Oh, there we go. Nice. Let's file a motion, right? That's what we do as lawyers. Let's file another motion. No, shouldn't get it. We file a motion. He should not be the trustee, but we lose. Judge goes, I don't see any reason why he can't be. Let's let him try. So at the end of the day, he becomes a trustee. She inherits $1.1 million because we were able to get some of it back from some arguments that we made. So we got $400,000 back. That's not a bad payday for that situation. But Jake is pissed. He didn't like his mom. Now, it's like, usually people like that, he didn't like her either. She got $1.1 million and made him really upset. Wasn't so necessarily, Cynthia got some stuff, but, he's upset that, he was thinking all these dollars he was going to spend. Now he got way less. So he wants more. Okay? So according to this, our client, we negotiated to buy out her life estate because she didn't want to live there anymore. She wanted to go back to the Philippines. So you can negotiate out buyouts of life estates. So they said, we'll give her $200,000 of the $800,000 home. She was going to get about $97,000 from the brokerage account. But she also got the joint accounts with rights to survivorship. So she got $375,000 there. Not a shabby payday, right? I might marry a 62-year-old man for $600,000 for 2 years. I mean, I'm not saying I wouldn't consider it. I could probably consider it just for a moment. I would talk myself out of it, but it's not a bad payday. So she did well for herself. Okay? But the story's not over, all right? Jake, he doesn't like this fact that she's going to get that much money. And he can't get it out of his mom because she got it through beneficiary designation. It's not part of the probate estate. Okay? So Jake goes to my nemesis, Probatius. He's the worst probate attorney that exists in this whole world. I cannot stand this man, all right? This man will take any case on a contingency, no matter how horrific his arguments are. He will show up purely to file whatever he possibly can, and he will not actually proofread anything that he files, and it will have other people's names all over it, and he will file it, and then he'll call you and go, how are we going to settle this? This is like game plan move. He knows I will make other people's life so miserable because he has it on a contingency. He knows he's going to get something. He knows people will get beat down with the constant attorney bills that they'll eventually go, give them $50,000, give them $100,000, just have them go away. But, so in this situation, he actually came up with a good argument. And I was shocked. And that was, he attacks the rights of survivorship. I thought if you have a joint account with rights of survivorship, it automatically goes to the spouse. Yes, if, like in the law, that's what you're always looking for. Ifs, unless, but, you got to make sure. You can absolutely inherit a joint account with rights of survivorship if you have the signature card. If you cannot produce the signature card, then you don't get it. Who in here has their signature card for their joint accounts with the rights of survivorship? Okay, no one's lying today. Good. All right. None of us do. Because, it should be at the bank, right? How many do you think banks keep those all the time? No, they don't. They'll get rid of them all the time. And so, she goes to get, and she can't produce it. You have to have, if you are going to inherit with joint rights of survivorship, you have to have a document that is in writing and signed by both parties. If not, it becomes part of the probate estate. And we lost because they were correct. And that money, now she had to take it out of her bank account and then sign it back over to the estate. And so she loses even more. Now, the good thing about Cynthia is for Cynthia, she came from a poor village in the Philippines. This was more money than she could ever possibly imagine. The other thing we were able to get was, his Social Security goes to Isabella, while she's a child. So that would help out too. So there was some money that was going to come in and help out. But it definitely was not what could have been done. And the bulk of the estate ended up going to where they. And then the story doesn't end because we have to fight for a few more years to finally get the warlock taken off as trustee, because he would not give any money to Isabella for anything, for any reason. And so we went in and were able to finally get him removed and get a nice family member appointed that actually was going to help Isabella. Okay? So, this is estate planning, okay? That's why we're here today. Let's go back in time, and let's assume you're an estate planning attorney, and Richard comes to your office. What are you going to tell him to do? You're an estate planning attorney, so what are you going to say? What do you want to say to this guy? What should you do? We got to figure out, who do you want to get your property? All right? What else should we be talking to him about? Did you ever create a will in the past? I need to know that. Get it in writing. Let's get this done. Yes, do you have your signature cards for your accounts? Do you know where those are at? These are all things, when people come to my office, that I have to sit down with them and go, do you have signature? There are certain things with certain people. When we're estate planning attorneys now, so we're figuring this out, and we're trying to do this. These are the things, because there are so many problems that can happen, because there's so many different things that can go wrong. So we have to figure it out. So, I'm going to do this. What would I do? So if Richard would have came to my office initially, I would have first scared the hell out of him. Because that's what I have to do, because everybody goes, my wife's dragging me in here, and why should I care? I'll be dead. They give me all the, okay, all right. I have to get them in the mind frame going, okay, well, what's going to happen when you die without doing anything? I have to explain to him what we just went through. Your kids are going to inherit the property. Cynthia doesn't get it. And here's the other issues that we can have. All right? You have an old will, right? Who'd you put as the trustee or beneficiary, the executor? Oh, my ex-wife, I think it was her father. She's still alive. Yeah, well, guess who's going to be in charge of your estate when you pass away? So the first thing, I'm sitting him down, I'm going to explain to him the first idea of not going through probate. You don't want to throw out all that money and give opportunity, because what happens when we go through probate? Then guys like probatious show up. Because your kids get notified, and then they are going to go hire attorneys, and that attorney is going to rile them up. You can get something, and you're going to end up in those kind of scenarios. So that's the first thing that I'm trying to convince, hey, you're a blended family. This is going to be a disaster. Now, if I have a husband and wife, they've been married to the same person their whole life, they have 2 or 1 perfect kid that never causes any problem, okay, I'm not so concerned about it. Well, do you have to avoid probate? It'd be nice. It will make things easier. It's going to be cheaper, but it isn't a disaster. There's certain people I have to go. It's going to be a disaster. Okay, the second thing, I'm going to tell him, you should create a bypass trust. What a bypass trust or credit protected trust for his wife, what he wants to leave to his wife. Because one, Cynthia, she's not from America. She's 25 years old. You're just going to give her millions of dollars and put it into her hands? She doesn't know what to do with it. You probably have someone managing that money for her.